ready start, feeling aggrieved and dissatisfied with the impugned judgment and order dated 24th June 2021 passed by the High Court of Judicature at Allahabad in writ tax number 328 of 2021, by which the High Court had dismissed the said writ petition preferred by the appellant herein, seeking direction to the respondents for consideration of the case of the petitioner under the scheme Sabka Biswas (Legacy Dispute Resolution Scheme 2019 hereinafter referred to as the scheme of 2019 The original writ petitioner has preferred the present appeal parachange. It is further submitted by the learned counsel appearing on behalf of the appellant that in the instant case the Honorable High Court has not properly appreciated the cause for which the appellant could not deposit the amount under the scheme 2019 on or before 30th June 2020. It is submitted that at the relevant time, and more particularly at the time when the form number 3 was issued, and even during the period under the scheme 2019, the appellant was subjected to the rigor of the provisions of the IBC by virtue of the moratorium period, which ended on 24th July 2020 when the NCLT approved the resolution plan para change. It is further submitted that in the present case, admittedly no payment was made of settlement amount under the scheme prior to 30th June 2020, and therefore the prayer of the original petitioner to extend the time limit to make the payment of settlement amount under the scheme 2019 was rightly rejected by the Commissioner, and the same has rightly not been interfered with by the Honorable High Court. Making above submission, it is prayed to dismiss the present appeal parachange. In a given case, it may happen that a person who has applied under the scheme and who was supposed to make payment on or before 30th June 2020 became seriously ill on 29th June 2020, and there was nobody to look after his affairs, and therefore he could not deposit the amount. Such inability was beyond his control, and thereafter, immediately on getting out of sickness, he tried to deposit the amount, and obligor approached the court. Can the court close its eyes and say that thou there may be valid reasons and obligor causes for that person's inability to make the payment, still no relief can be granted to him? There may be extraordinary cases which are required to be considered on facts of each case. The courts are meant to do justice and cannot compel a person to do something full stop.